bono political award by the American Bar Association Standing Committee on Pro Bono and Public Service. He's a graduate of Harvard Law School. And we thank you all for joining us today. We're going to start with Mr. Pope and asking you to speak a bit about what's going on there in Michigan, the impact of COVID-19, and more on how it's impacting this current election season. I turn it over to you, Harold. Harold, okay, there you go. No, you're still muted.
I wanted to thank you for letting me participate in this most important event. And I'd also like to thank Neil and Ezra for wearing the appropriate uniform, because it looks like we all got the same thing on. So Harleen and Kristen also are in the green. Marcia, you're a little off, but that's all right. So anyway, in Michigan, we really had a significant impact. I think we're like the 4th hardest state hit by COVID-19. We have close to 60,000 cases and 5,500 deaths. Communities of color are hardest hit, as 37% of those infected have been Caucasian, while 31% are African American, 8% categorized as multiple races, 2% Asian Pacific Islander, 1% Native American, 5% other, and 16% unknown. The fact that Michigan has the largest population of Middle Eastern descent in the US, as well as a significant Hispanic population, makes me believe that the other and unknown categories may be heavily populated by underserved communities. However, the rate of cases is subsiding and the state is carefully reopening, and restaurants and retail will even soon open in the city of Detroit. So then we have to figure out, how is all this going to impact voting in Michigan? So fortunately, Michigan has some of the most liberal voter access laws in the country. You can request an absentee ballot without providing a reason for doing so. We also have same-day registration. Of course, as we just saw, I think it was last week, it might be the week before, because things in the era of the man whose name will not be mentioned, in this era, things kind of go rapidly. But last week, we saw that someone misinterpreted Secretary of State Jocelyn Benson's actions to send out applications for absentee ballots to all registered voters who had not yet requested one, as an illegal act of actually sending out the actual absentee ballots to people who hadn't requested one. And as always, for many of the people, both on the panel and some of the people I know that are watching this webinar, know misinformation and problems at the polls with equipment and training of poll workers will always be a problem. However, in Michigan, attorneys from our partner organizations, including Sharon Delente, the voting rights strategist of the ACLU, and Kalila Spencer, the general counsel for the NAACP state conference and a partner at Honigman, were part of Secretary Benson's task force to address voting reforms with a number of county and city clerks. The thing we also have to be mindful of is the fact that the RNC-DNC consent order related to challengers at the polls has expired, so that we may encounter some aggressive challengers in areas with large populations of people of color. However, in those jurisdictions, the governmental authorities will not sit idly by while harassment occurs. For instance, in 2004, I believe it was 2004, it may have been 2008, I'm getting old, but the city of Detroit arrested overly aggressive challengers in a precinct. Finally, our friends at the ACLU, who I mentioned before, have brought an action on behalf of the National League of Women Voters to compel that all ballots postmarked on the day of the election be counted. Right now, they're only counting ballots that are received on the day of the election. Nearly 1 million voters requested absentee ballots in the presidential primary. 804,000 people had returned their ballots by the Monday before Election Day, a 60% increase over 2016. And 1.75% of the absentee ballots were postmarks on the date of the election and not counted. The suit that is currently being prosecuted by ACLU asserts that with 7.7 million registered voters, approximately 134,000 votes would be invalidated without judicial relief. And obviously, because of COVID and because of the push to actually have people vote absentee, that number could be higher. So that basically is an overview of what's happening in Michigan, at least from the legal side, some of the issues that we think will come up. But we have a strong cadre of people working here. And I know that there are people in Michigan watching and hadn't decided they're going to sign up too. So we believe that we will work through any problems that we will get in Michigan. And we're going to work very hard to make sure that everybody that wants to vote actually votes and has their vote counted. Thank you.
Thank you so much, Harold. And thank you so much to Marcia Johnson Blanco for getting today's important conversation started. My name is Kristen Clark. I'm President and Executive Director of the Lawyers Committee for Civil Rights Under Law, and we're really pleased to all of those who have joined us today. I thank Harold for setting the stage for this discussion by talking about COVID's impact in Michigan in particular. We know at this stage that there are about 105,000 Americans who've lost their lives, and we're moving close to about 2 million infections across the United States. So no doubt 2020 is an election season where we will continue to be contending with the impact of the pandemic. And just to further set the stage, since we advertised this event, we are now contending with a new and unanticipated challenge in the wake of the mass demonstrations and protests that have unfolded across the country, unleashing National Guards and state police officers and local law enforcement in ways that could potentially have an impact on electoral access. We know that the deployment of law enforcement historically has had a chilling effect on voters of color. So I plant that seed just as something for us to be thinking about as we go through this conversation today. But the pandemic and its impact on the election is something that litigators have been contending with. And so at this point, I want to ask Ezra Rosenberg and Neil Steiner to help us understand the current litigation landscape. There have been some wins and there have been some losses. Maybe we can start with a discussion about why the track record has been somewhat mixed when it comes to courts addressing the impact of the pandemic on the election season.
Thanks, Kristen. I'll start off in answering that question. And it has been somewhat of a mixed bag. And there have been suits probably in more than a dozen states around the country dealing with various issues of absentee ballot expansion and dealing with the eligibility issues, with procedure issues. And by and large, the courts have not been particularly welcoming to these suits. And I think the main reason is that they've been postured at necessarily in the context of temporary restraining order applications, in the context of fairly fast-moving facts. So you have a situation where the courts are saying, in the first instance, they want to defer to the executive branch and to the legislative branch for providing answers to these problems. most recently, I think people might have seen the decision that came out in a non-voting context in the case of South Bay United Pentecostal Church versus Gavin Newsom coming out of California. It was a Supreme Court decision on a motion for a stay, and the issue there had to deal with the California order that limited church gatherings to 100 people or more than, or no more than 25% of capacity. And the argument there was, well, you can't violate religious freedom. And the court said, well, in a 5-4 decision with the 4 liberal justices joining not the opinion, but the decision of Chief Justice Roberts, that in fact, they were not going to stay the order. But the key language I want to highlight is Chief Justice Roberts saying that the precise question of when restrictions on particular social activities should be lifted during the pandemic is a dynamic and fact-intensive matter subject to reasonable disagreement, and that should be left in the first instance to the governor and to the legislative branch, particularly when a party seeks emergency relief in an interlocutory posture. And I think that's one of the reasons why there have been some losses in this area. There's been another case in the voting arena in the Middle District of Georgia where the Coalition for Good Governance brought a suit looking to ensure, to change the date of the primary election in Georgia, to mandate paper ballots and to allow for pop-up ballot boxes and things like that. And the court said these are political questions that a court does not have manageable standards to apply. So I think that's the main reason right now that you see losses. It's in kind of a new area for the courts. They're deferring to the executive and legislative branch, and these are brought on temporary restraining order process. Neil, you want to add? You're on mute. You're still on mute.
If we take a step back and look at the source of the right to vote and the various places that the right to vote and a fundamental right to vote has been recognized and come from, that sort of dovetails with what you're saying about there being a little bit of a, some of these decisions are viewed as political decisions and not necessarily judicial, or more of a hesitancy on the judicial front. But the Supreme Court has long recognized that there's a fundamental right to vote. The source of that right, it's found, is in a combination of the First and 14th Amendments, and I think both the Due Process Clause and the Equal Protection Clause of the 14th Amendment. But those rights, the Supreme Court has said, have always been subject to a balancing of how unfettered or restricted the right to vote is versus the state interest that's at play. And that was in a series of Supreme Court cases in the 80s and 90s that is now typically in the voting rights world referred to as Anderson-Burdick. And that's generally speaking how federal courts at least start the analysis, which is to say, while everyone has a right to vote, and along with the right to vote, I think going back 150 years, the right to vote includes the right to have your vote counted in Supreme Court precedent. There is this balance to say, well, what's the state interest of any type of regulation here, the health and safety, health and welfare aspects of things versus the ability to exercise the right to vote. And then along with that, there's a Supreme Court concept that was developed in a case called Purcell that said, well, you can't go around and change elections you can't change the rule of an election on the eve of an election. And we've seen that both positively and negatively used by the courts to say, even if there's a violation here, we're not going to issue a restraining order when you're within a week or when you're within a few days of an election. And so as litigators seeking to protect voting rights, it's a balance that we always have to contend with. You don't want to be too soon and have courts say your injury is speculative. How do you know things will be so bad? And the flip side, you wait too long and the courts say, well, we see there's a problem here, but the election's tomorrow. What are we supposed to do about it? And I think that kind of dovetails with what a lot of the courts have been struggling with, and even trial courts saying, well, maybe I should grant an injunction, and an appeals court coming in and saying, not so fast, not attacking any of the reasoning, only the timing.
So a lot of this litigation has been focused on the primary election season. Share your thoughts about what you think we should anticipate with respect to the November general election.
Ezra, do you want that first, or do you want me to?
Why don't you start and I'll follow you.
Sure. So, so the primary, the general election in November is obviously it's a date that's set by Congress, and we have to have the election. There's constitutional turnover in terms of when the new Congress is sworn in, but that date's the same for everyone. What we've had so far is a series of litigations and series as the pandemic's been growing, of different state challenges where the primary election is much more of a function, while there are some federal laws that still apply, it's much more of a function of states having more discretion. And while the states continue to have discretion over how elections are conducted in their state, the federal government also has that role of ensuring that there is an election, in my view, in November. And I think a lot depends on what's going on with the pandemic, but that's exactly where right now I think, there are worries as to what's the world going to look like, and how do you vote with social distancing, and do you need expansions of things like early voting and expanded access to early voting? Should every state have no excuse absentee voting? So right now, while there's a fundamental right to vote, that does not include at the federal level a right to vote either early or by absentee. That's one of the things that's left to the states. We currently have a system, I think, before COVID, where I want to say it's 34, I could be off by 1 or 2 states allowed absentee ballots or early in-person voting, which is functionally kind of the same, gets you to the same place, with no excuse. Anyone could go and do it within the time periods that the state set. Of the other states, I think that 11 or 12, in light of COVID, have said, well, we're going to expand that. And while we generally don't have, while generally you might need a reason to vote absentee, we'll say anyone who is concerned about COVID, is at risk, is in a high risk group. Really, if in your mind this creates an issue, that's an excuse for you to be able to vote absentee. 5 states have said, no, we're not changing the rules there. And I think that there's litigation, if not against all 5 of those states, certainly against 3 or 4 of those states, over expanding access to absentee voting at that level. And I think, and so we have that, the states that have expanded and said no excuse, the Republican National Committee's come in and sued 2 of the states and said, you can't do this. So that's something that's clearly on people's minds, not just for primaries, but for November. There's a little bit of an issue now where you want to litigate that claim far enough out, but there's a risk that if you bring that claim right now in a federal court, really on either side of that issue, that a judge says, well, November's a long way off. We don't know what the world's going to look like. Yes, you can have doctors put in testimony as to what they think, but no one knows. Your relief's too speculative. That's as we sit here at the beginning of June, 5 months off. If you waited until October to bring that claim, you'd have people saying, and judges saying, look, you might have something here, but why'd you wait till October? We can't go change the rules on people on October 15th for an election that's on November 5th or 6th. And so I think that there's going to be a lot of litigation over issues like that, the exact timing, the exact claims to be developed. And I think we're seeing what's happening in a lot of states, and that will add to the facts. Ezra, I don't know but the primary litigation, I think, will add to what happens in November. But Ezra, I don't know if you have more to add to that.
Yeah, let me pick up on some of those themes. To put what's going to happen in November into full context, we have to look at what happened in the primaries and before. As Neil indicated, most of the states in this country do allow for absentee ballots or vote by mail without excuse. 5 of the states are completely vote by mail states: Colorado, Washington, Oregon, Utah, and Hawaii. And the rest of that 33, 34 states either allow their local jurisdictions to vote by mail, to allow vote by mail, or have what's called no excuse vote by mail. The litigation during the primary season has focused on those states that both had primaries during the public health crisis and do not allow no excuse vote by mail. They typically have a statute that says you can vote by mail, but only if you meet one of certain strict criteria dealing with disability or illness. And it's in those states where the litigation has been pretty much hot and heavy. Some states, as a result of the litigation, such as South Carolina, moved to no excuse absentee ballot. We have now filed cases in several of the states. We and other organizations, we filed in Tennessee together with Campaign Legal Center to force them to go to a no excuse vote by mail regime for the November election. Similarly, with the ACLU, we filed against the state of Kentucky, seeking the same relief against the state of Kentucky. And in that complaint, for example, addressing one of the issues that Neil raised, which is, well, how is the court going to say what's going to happen in November when you're filing in May? Yet if you wait till October to file, the court's going to say you waited too long, and they're going to apply the Purcell doctrine. So what we've done is we're saying, well, there's a way of tailoring the relief to the circumstances, so that, for example, the relief we want in Kentucky is tailored to circumstances where either a public health crisis has been ordered, has been designated, or people are being told to shelter in place. So if those criteria are met, then you don't have to speculate anymore, and relief can be granted. And that gets around some of the problems that Neil mentioned.
So just a reminder for our participants who are joining us today for CLE credit, the CLE code for this program is 601. 601.
Kristen, I think it's vote 601. Vote 601.
Thank you, Neil. Vote 601. And we'll put that in the chat box. So I want to ask about some of the burdens that are imposed on those who are vote by mail and those who are participating by way of absentee ballot, which is essentially one and the same. And that's about notary requirements. We know that there is this history of imposing requirements on voters who are casting absentee ballots, that those requirements can sometimes prove problematic and prove to be a hurdle. But on the other side, there are those who express concerns about fraud. So I want to put the question on the floor. Basically, are notarization requirements necessary to prevent fraud? And I want to ask that question being mindful of the current pandemic, which makes access to notaries a little challenging.
Right, and I'll start off on that one, Kristen. There are a few states that do have notarization requirements. Matter of fact, even before the pandemic, we sued the state of Mississippi because they have a dual notarization requirement that mandates that you have to have your absentee ballot application notarized and the absentee ballot notarized. And in the case of an election runoff, there's only a 21-day period. It's an untenable situation. When there's a pandemic, it has been impossible for voters to get their absentee ballot applications or ballots, if that's the requirement, notarized. So that deprives them of the right to vote. And in specific answers to your question as to whether it's a way of stopping fraud, it's not necessary, because the voter has to sign a statement under oath, subject to perjury, that the voter is the voter, that the person signing the ballot is the voter. There are also other, perhaps less onerous ways than a notarization to substitute for a notarization requirement. But again, it might be something like sending a copy of your photo ID, but that again, in the case of pandemic, may be impossible for some people. There's been some litigation on this issue. An Arkansas court refused to throw out the notarization requirement. The Oklahoma Supreme Court, however, did throw out the notarization requirement, but then the Oklahoma legislature turned around and passed a law reinstating the requirement and saying that if you cannot get notarization, then you have to, as I indicated, send a copy of your photo ID. But that, again, may be impossible in the case of a pandemic.
Anybody else?
I do want to add one other thing, which is the idea that there is widespread voter fraud, either certainly in person or by way of absentee ballot, is just not true. And even those organizations like the Heritage Foundation and others who've tried to convince state legislatures that there is widespread voter fraud, come out with statistics such as 1,400 examples of voter fraud over a 14 or 15-year period. You have a much greater chance of being struck by lightning than you have of witnessing actual voter fraud.
Yeah.
Ezra, I think, that was certainly an issue in the Kansas case that I tried on the documentary proof of citizenship with the ACLU, where the trial judge and then the 10th Circuit recently affirmed the factual findings that there basically was virtually no evidence, when the state was actually tasked to putting in evidence. They came up with virtually no evidence. I think they had a dozen or 2 dozen possible instances over a decade or more period, and they conceded that most of that was just mistake and not fraud. And so that's finally, I think, started to get a little bit of the right attention of this notion of widespread voter fraud is really just a myth.
So just to move in a slightly different direction, there's an interesting pattern that we're seeing this election season, which is a lot more voting rights litigation in state courts. It's probably fair to say that we've seen a disproportionate number of these battles brought to federal courts, but there's a mix this season for sure. Why do we think that is, and what are the implications?
Sure. So just for starters, Kristen, and then Ezra, if you want to jump in, or anyone else, some of the, there's a mix of assessments of state court versus federal court, given the current makeup of the federal courts. And it's also the case that under state law, some states have specific protections that go farther than the federal protection. And so some states have state constitutional provisions that in the state constitution, there are guarantees of equal access to the ballot, that all citizens have access, phrased in different ways. And so in some states, there are, I think in Pennsylvania comes to mind, Tennessee comes to mind, there are specific state protections beyond the federal protection. And then there are even, I think there's state court litigation and federal court litigation in Texas where there isn't such a state constitutional provision. But I think different advocates have different views as to whether the Fifth Circuit or the Texas Supreme Court is a more receptive ultimate arbiter of constitutional voting rights. I don't know, Ezra, if you've.
Yeah. I mean, that's right, Neil. And in fact, I don't think the track record has been all that much greater in state courts than in federal court. Pennsylvania, there have been a number of cases that have not gone very far. Missouri, the trial court denied the motion for preliminary injunction dealing with absentee ballots, and that's up before the Missouri Supreme Court. And Neil mentioned Texas, where there have been both federal and state court actions, and the state court action was decided by the Texas Supreme Court last week, and that had to do with whether or not the word disability in the absentee ballot statute would include a lack of immunity to COVID-19. And the Texas Supreme Court said, no, it does not include that, but then went on to say that they're going to leave it to the decision to apply to vote by mail, and I'm reading from the opinion, based on a disability is the voters subject to a correct understanding of the statutory definition of disability. So they said they're going to leave it to the election, to the voter to decide. However, the voter has to decide, apparently in the context of their opinion, which says it's not a disability. And if the voter says he or she is disabled and therefore cannot vote, the election official supposedly is not going to second guess that, but it still leaves voters completely up in the air in terms of are they doing something that's legal or not legal? And Texas is not necessarily a state that I would want to be unsure.
So we're getting some good questions through the chat box, and I want to encourage folks to continue sending your questions. Actually, if you can hit the Q&A box, that works a little bit better. Harleen, I'm going to turn to you in a moment, but before I do that, we got a very interesting question about whether notary requirements raise poll tax issues. And I wondered, Ezra, whether you could comment on that.
They can raise poll tax issues, although again, it's going to the courts have not been particularly friendly recently to poll tax, except recently, just last week, the Florida trial court ruled that requiring those who had completed their sentences for felonies to pay all of the fines associated with their original conviction, that did constitute a poll tax. So that does add kind of a glimmer of hope that the poll tax restrictions might be alive still.
And Ezra, in Mississippi, where there's a double notarization requirement that we're currently litigating together, in notaries in the state of Mississippi are, I think, required to notarize without charge. And while it's termed a notary requirement, they'll also accept if you're out of state or if you're in state, things like a postal clerk witnessing your signature. So there are not publicized and therefore difficult for anyone to actually figure out, but alternative means of getting the attestation without charge that theoretically get around the poll tax issue. I think that still has a big impact on how that affects less educated, less affluent communities. I think is still a big issue on the notarization requirement, but there seem to be ways to get around the poll tax.
Yeah, but bottom line should be that if this is the only way a person can vote and they have to pay a certain amount of money in order to do so, that sounds to me like a poll tax.
And there's been lots of talk about absentee ballots and opening up to absentee ballots this season. We also received a question about the unique issues faced by Black and Latino populations, and whether or not their applications may be denied or rejected at higher rates. Ezra, I wondered if you could talk a bit about Gwinnett County, Georgia. And it's not just Black and Latino populations, but I know that Native American populations also face unique issues here.
I mean, I think it's been shown around the country that, for example, those states that have signature subject absentee ballot applications to, or the ballots themselves to signature match requirements, that minority voters from minority communities find that their applications are rejected at a higher rate than those of white voters.
And there's also the interesting experience out of Utah.
I'm drawing a blank, Kristen.
Navajo speaking voters.
Yes, I mean, the Navajo Nation in Utah, Navajo, there the issue is vote by mail generally, because the Navajo Nation, for example, many of the roads are poor roads. The mail is delivered sporadically, so vote by mail to begin with is not a primary choice of many of those who live in the Navajo Nation. They sometimes only get their mail once a week. They have to drive over these poor roads to the postal centers. So that really underscores another point, which is vote by mail cannot be the only option that people have to vote in the context of the pandemic. You have to have in-person options, and particularly expanding early voting.
Yeah, and one of our participants notes that voter ID is an issue there as well. That's absolutely right. And for both of these examples involving Gwinnett County, Georgia, and the Navajo community in Utah, there was some interesting litigation that we brought at the Lawyers Committee for Civil Rights Under Law. We'll actually pull those links and share those links so folks can kind of see how the courts, how these issues were handled in the legal context. But we're getting lots of questions about the role for lawyers in all of this and how can we employ and activate law firms. And I want to bring Harleen into the mix here and ask you to talk a little bit about election protection and your firm's role in the EP program.
Thank you so much, Kristen. First, I just want to say I love talking about election protection. My firm has run 9 call centers, and my first time when I ran a call center was in 2008, and I've done it every 2 years, and it is absolutely one of my favorite activities ever of all time. And in fact, all day this morning, I have been running my firm's call center. We are helping voters in Pennsylvania. Their primary is tomorrow, and there are a number of contested elections tomorrow. So we've been answering calls from voters all morning. It's very, very busy. And, you know, interestingly, when I first thought about how election protection dovetails with the pandemic, which is the focus of this panel, you know, I was going to say that I really don't think it's going to bring up a lot of new issues. I think it's really going to exacerbate issues that have been going on for a long time. I don't know that I would say that now because we are facing some things that we've never seen before. For example, there are a number of curfews in place in cities in Pennsylvania, and those curfews may also be in place tomorrow when the polls are open. And the curfews may force people to be home prior to the polls closing. So that's an issue we've never seen before that we're working out. We're also dealing with a consolidation of about 60% of the polling locations across the state, which is an enormous number of consolidations. It's causing a lot of confusion about where to vote. And we've seen these issues before as election protection volunteers in many states. There's often confusion about the law and procedures on the ground. They often change from day to day. So it's been an exciting morning. Just to give people an idea of what election protection is and how it works, it is the nation's largest nonpartisan voter protection program in the country. And the goal is both to increase access to the ballot and to help solve problems at the polls. It seems pretty simple. But it's successful in part because thousands and thousands of volunteer lawyers across the country take callers from voters through this program. And that's what we're going to talk about today. EP began as a project of the Lawyers Committee after the 2000 Florida election. Does anyone remember the hanging Chad debacle? That is what prompted this program. The idea was that voters need to help resolve problems on election day because oftentimes when you resolve these problems after election day, it's too late. EP has evolved into a year-round effort to improve election administration. We got a question earlier about whether the call centers are active today and at other times during the year, and yes, they are active all year long. The DC Office of the Lawyers Committee runs a year-round hotline for people call in and get help with all kinds of things from registration to ballots to other issues. And that has really been a game changer, I think, across the country. We've learned that many voting related problems are best prevented ahead of time and by working with election officials, passing new laws, et cetera. And that's the work that the Lawyers Committee does between elections. That's the work that Ezra's talking about, that Neil's talking about, that Chris is talking about, Carol. But they know where those problems are in large part because they get reported in by volunteers, by hotline volunteers. And that's how those programs work together. The way that election protection works is that it trains volunteers to answer calls from voters from specific states. So voters assist individual voters, like where are they registered, where are their polling places, but they also record important data. There are 5 broken machines at my local polling places. And that allows the sort of chain of command, people on the ground and people in the national office to fix those issues as they arise. Election protection runs both a hotline, so callers can call in to 866-R-VOTE, and a field program. And both are really important and both work together. They've got volunteers on the ground all across the country that are at the polling sites, reporting in problems, helping voters, and also callers call into that hotline. The synergy of these 2 programs, I think, is what makes it so effective. And why is this work important? I have 3 examples that I really like. One is the most obvious, I think. The hotline volunteers help individual voters, right? So a voter comes in, presents ID at a polling place, the poll worker is confused about the law, the poll worker says, I'm sorry, that ID isn't acceptable. They call election protection will get on the phone with the poll worker, read them the law, the poll worker will accept the ID. I'm making it sound very easy. It's actually not that much more complicated than that, and I've done that before as a hotline volunteer. But it also fixes problems that impact groups. So in 2012, my firm's call center got a call from several Indiana voters saying that the TV news anchor was reporting that the polls were closing earlier than they actually were supposed to be open until. We tracked down the broadcast and determined that the Indiana broadcast was covering certain Michigan cities, and they didn't realize it, and they were in 2 different time zones. And so we were able to get that broadcast corrected. Those are the kinds of things that make a difference on election day. And the third is that it helps fix systemic issues, and this is often with help from the national office. A great example is in 2012, the election came on the heels of Superstorm Sandy. I don't know if any of you East Coasters remember that, but it was a pretty chaotic time. And in New Jersey, there were 10,000 workers who came in from all over the country to help the state recover from severe flooding and damage from the storm. The EP call center that was handling New Jersey got a call from the manager of those workers, and he said if there wasn't a way for them to vote in New Jersey through an emergency order, the unions were going to pull all the workers out of New Jersey and send them back where they came from. That would have been a disaster for New Jersey. There were already some emergency orders in place in New Jersey and New York, and with the help of the EP National Office, the call center volunteers tracked down all of the states that those workers came from and managed to secure emergency orders for all of them so they could stay and vote. That example always strikes me as incredibly powerful, because if this system weren't in place, that might not have happened. And so it's really impacting the small individual person and the big groups. Just a quick example of what types of issues have come up in which voters have been able to help. Things like broken voting machines, poll workers not offering provisional ballots when they should, police presence at polling places, electioneering and intimidation at the polls, confusion with voting laws. This is all very common, and election protection staff really creates these very easy to use top issues and frequently asked questions, and that's how volunteers answer those questions and deal with those issues when they come up. This year is going to be interesting because of COVID. We don't know yet how it will impact the election in November, but we and a number of other law firms have been piloting a remote election protection call center. It's actually the first time we've ever done it. It has worked remarkably well. I've been very impressed. And should we have to do a remote call center in November, I think we will be ready, but we definitely need help. And if you are someone who wants to volunteer and wants to know how to get involved, it is very, very easy. Election protection is currently recruiting lawyers, paralegals, law students, and other professionals in a number of states across the country to help with elections in 2020. And the thing that is important to note is that unlike voting rights litigation, where you really have to be a litigator to do that work. You know, I'm not a litigator. I don't actually work on the voting rights litigation that my firm does. The litigators do. EP can be done by any legal professional, regardless of their specialty or experience. In my firm, we have volunteers from real estate and funds and capital markets and IP lawyers, just to name a few. It really just matters that you care about fair and accessible elections in the country, and then you'll be able to help. So for all of you out there that aren't litigators and, you know, don't feel ready or able to bring an impact litigation in a state, you know, this is really a great way to volunteer. There is a link that I'm putting right now in the chat box. It is electionprotection.wetheaction.org. You can also just Google election protection volunteer, and this will come up because I did this yesterday. It is so easy to volunteer. You click on a button and it'll ask you to fill out a very, very basic profile. It just takes a couple of minutes, and it will give you all the training materials and offer you time slots in call centers to volunteer. You can do either the field program or the hotline. Anyone can do it. We have hundreds of our lawyers at Simpson Thacher who volunteer every year to do this. It's incredibly satisfying work. They really love it. And you know, all I can say is I think we need all the help we can get. Every year this program gets bigger. We get deeper into every state. We get more people on the ground, and we get more calls because we push the number out more. So we really, really need your help. If you are in a large firm and you have a pro bono professional at your firm, you can ask that person how to do it, and I'm sure they will have a contact of the lawyers committee, because I think most firms do. And I really encourage you to do so. It's a really wonderful program. It's easy to get involved with, and you'll be making change and bringing help to people who really need it.
Thanks so much, Arlene, and grateful for your support. And it looks like we've got a number of participants today who've been a part of the election protection program throughout the years. So many thanks to all of you for joining and for all that you do to support the program. I want to encourage folks to continue sending in their questions by hitting the Q&A box at the bottom of your screen. I'm going to chime in and just share one of my favorite examples of how lawyers really help to breathe life into the election protection program. I can recall a very vivid moment during the last presidential election period. Virginia, it was October, and people were trying to register to vote online, which is great. Virginia is one of those states where you can register to vote online. It was the eve of the election when lots of people tend to go on ahead and get registered, and the system crashed. We started just hearing complaints from people all over the state saying, I don't know what to do. I'm trying to vote. I'm trying to get registered. What do I do? We reached out to the state and we said, look, this is the lawyers committee and we've got lots of complaints. Get your system up, but most importantly, extend your deadline so people get a fair chance to get registered. The state refused, and with our law firm partners here, in this case, it was Arnold and Porter, we marched into federal court and got a 36-hour extension of the registration deadline, allowing about 25,000 people across the state of Virginia the opportunity to get registered and added to the rolls. So that would have been 25,000 people locked out of the last presidential election season, but for the power of emergency litigation and swift action in partnership with a law firm to go in and get a successful result. So it is a program that really is anchored on partnership with the private bar. So we're grateful that lots of you are expressing interest and hitting that link that Harleen shared. Ezra, I've got an interesting question that's come in that I'd like to share with you.
Sure.
someone has asked whether it be possible to seek a TRO against President Trump, arguing that he himself has had a chilling effect on absentee balloting due to his insistence publicly that it's subject to massive fraud.
From your lips to God's ears, as much as that sounds like the sort of thing that one should be able to do, I do not think that. I think most courts would probably kick it out at the first instance. I did want to just raise, if I can, just very briefly and pick up something that Harleen said and what you've been saying about the firms. The firms have been instrumental in terms of what we've been doing and other organizations have been doing in litigation. The Covington firm's been working with us on the Kentucky case, Deckard, of course, Shepard Mullins, Simpson Thatcher. So I think it's important to recognize not only in the election protection side, but in litigation, how important the firms have been.
Great. Let's see if we can take another question. So in the past couple of years, historic numbers of immigrants naturalized, and there have been historic numbers of immigrants who've been naturalized and who were able to vote. What kind of issues are we seeing now for these new voters? And I guess the one observation that I'll make as I tee that question up is that you've got a fair number of people who've gone through the process of seeking citizenship who are now waiting for that last step, their oath ceremony. So they've gone through all kinds of security checks and background checks, and because oath ceremonies have been canceled or postponed, it is questionable whether many of those folks will get the opportunity to get sworn in and the opportunity to vote this season. What are our thoughts about this particular issue?
Well, I think that's one issue that you just raised, and the other is the problem that some naturalized citizens have in getting to register to vote in the first place. We have a suit that's pending in Mississippi because Mississippi requires only naturalized citizens provide proof of citizenship when they register to vote, and that really is it's just unconstitutional. So we have a suit that's pending there. So there are burdens that are placed on naturalized citizens that are not placed on citizens generally, and that's what makes that unconstitutional.
Marcia, we're getting some questions from folks who are asking about our field program and plans to deploy people to actual polling sites this season. Can you talk a little bit about the lay of the landscape presently?
Sure. Thanks, Kristen. And I appreciate it because I had trouble answering them in the chat. Yes, so right now we're trying to figure out what our field program is going to look like in our individual states. As Harleen mentioned, it's unknown what November is going to look like. But what we suspect is that we're going to have a mix of states that have vote by mail primarily, but with in-state options. And for those, we're going to have likely have mobile field programs. And so rather than having poll workers stationary, poll monitors stationary at polling places, we would have volunteers who are roving, as we already do in some states, and stopping at individual polling locations to determine whether voters need help. So that's something that is going to be a work in progress. But if you sign up on the WEDI Action site, even if there aren't any shifts available now, you will get a notice when shifts are available in your jurisdiction and what type of volunteer opportunities are available there.
Can I just come back in, because here in Michigan, we've always coordinated with the non-attorneys. And the way we run our field program is that we usually have more non-attorneys working with us than attorneys. And what we try to do is place non-attorneys in the polling sites, in one polling site, and then that pairs of attorneys go on a circuit from polling site to polling site to check in to see what's happening and to address any issues that are happening in those polling sites. And I suspect and I hope that because of all the great work that's been done by this panel, that people will be jumping up and down to volunteer, and we will just have everything covered here in Michigan in August and in November.
Okay, well, it looks like we are at time. We want to thank all of our panelists for joining us for this session, Activating the Private Bar to Safeguard Voting Rights in the Age of COVID. This program is being recorded. We will circulate a copy to participants. We encourage you to visit the 866ourvote.org website to learn more about election protection. We also encourage you to visit the Lawyers Committee for Civil Rights Under Law's website to learn more about the litigation that's playing out all across the country to safeguard access to voting rights. Many thanks to our extraordinary panelists for today's presentation, and thanks so much to all of you who are watching for joining. Take care.